Hello, lovies. Welcome to the inaugural stream of Nurse Kim YouTube Live. Who am I? What am I doing? I have no idea. Thank you very much for joining me this evening on Sunday, August 4th, 2024. And I am so happy to be here with you guys. Thank you for everybody who has showed up and showed me some love in the comments before I even got on. I feel incredible. And backstage right now is the reason that I was able to do this and that I have so much incredible support. It is the one, the only attorney, Mark Bederow, who has brought us all so much joy in the Karen Reed trial, in his breakdowns of what is going on, telling us things that, we might not be able to understand otherwise, and breaking it down for us to feel like we're in the trenches, right? Which we have been, as we covered 9 weeks of trial together. So without further ado, we're going to bring on Mr. Mark Bederow, and I want to make some merch for him that says, "Uh-oh, better call Bederow." I don't know. All right, I'll work on it with him.
How are you?
Hi, Mr. Bederow.
I love the Better Call Saul comparison. In fact, back here on my shelf, I have my Better Call Saul bobblehead. So,
listen,
yes.
I knew that about you. See, there are things that I would figure you would enjoy that.
Better Call Saul is actually somewhat realistic. Not the drama part of it, but I don't know how close you watch that show, but there's about a season or two where he's working at a law firm, a semi-large law firm in New Mexico. That's very realistic, that law firm type of life. But yeah, Better Call Saul, all-time favorite.
That's awesome. And I was wondering, Mr. Bederow, so when I asked you to do this with me, you were so kind and you were like, "Kim, I got you." And I was wanting to go through with you, like, your education and your career, because we know that you know everything that is Karen Reed trial, right? And that you've been our go-to guy. And I have to I will give a thank you to Mr. Mike Crawford of the Young Jerks for introducing us all to you. And, it's been a pleasure to see you on YouTube and in any platform and on Twitter and getting all of your legal takes. But, and also I'll throw out a shout out to Turtle Boy for keeping you in our graces and keeping you in the Massachusetts, circuit court for a while. But, I don't know much about you I've researched it, but I would like you to maybe, if you're comfortable with talking about, the undergrad of Arizona State. And then did you go to Syracuse Law School?
I did. Yep.
Yeah.
So which is just foolish because Arizona's paradise. It doesn't rain except for January and monsoon season. It's sunny every day. I don't think the first year I was out there, I ever wore anything other than shorts, literally at any given time. Weather's perfect, sunny every day. And for some silly reason, I left there and went to law school in pretty much the worst weather in the country, which is upstate New York, which Syracuse, it's in between Buffalo and other godforsaken places where it just snows endlessly. But yeah, no, so I did. And then after Syracuse, I wanted to be a prosecutor, which is, the best job you'll ever have if you do it honorably and properly. That's certainly open for debate in the case that we're talking about. But so I wanted to be a prosecutor and ended up in what is the preeminent prosecutor's office in the country, which is the Manhattan DA's office. But I'm Boston born and bred. So like anyone else, if you had told me that I would end up in New York City, I would have said that's impossible because like you and everyone else, I was taught to detest the place, hate it, everything about it, primarily the sports,
The
obviously,
sports, right?
which I still do. And I will tell you, in the first few years I lived there, it was tough. In the heyday of the late 90s and early
Oh,
2000s, Yankees dominance and all of that crap. But that worked out okay, as you know. But yeah, I wanted to be a prosecutor, so I applied to a few places and ended up at the top of the hill. And so I moved to Manhattan and worked there for about 5.5, 6 years in the office, which was, again, best job you'll ever have. A lot of fun. And after that, I was recruited by someone I had an interesting case with, who brought me into a large law firm. I guess, we were good adversaries, and rather than fight, he, lulled me in, and with dollar signs and all kinds of
yeah.
things like that. And eventually you do it. And I stayed there for about 4 years, and I liked it, but also determined that I wanted to be my own boss ultimately, rather than traditional large firm partnership, which has many advantages, but also you don't control a lot of what you do in terms of, business politics and that sort of thing. So in, God, it's been 2008 already. It's that long ago. Opened my own practice in New York City, in Manhattan, and have been doing that ever since. And I love it. So here I am.
And there you are. And I did see that while you were the ADA in Manhattan, and I know that that's literally the busiest DA's office, right, in our entire country, that you prosecuted some really incredible cases with specifically a New York hate crime statute for a German national.
Uh, Matias Goldner. Yes. New York, actually, it was the very first indictment under New York's hate crime statute ever, which only went into effect right after 9/11 or thereabouts, maybe right around the time. So I don't know how many of you know New York City or not, but Matias Goldner was a German national who lived in the top floor of what's known as the Corinthian apartment building in New York City. And again, if
Mhm.
you know Midtown Manhattan, it's a 57, 58-story luxury building. It's right outside the Midtown Tunnel. It's very unique architecture, but nevertheless. So he was a German national living there, and he worked at the United Nations, and worked, I don't want to get into the politics of it, but he
Mm.
worked on issues related to Palestine and Israel and whatever you want to call it politically.
Yeah.
So in December of 2001, which, as you can imagine, in New York City was, pretty strange times. And I mean,
Yeah.
really, New York on 9/11 that's a whole nother, for another day, perhaps, being about 5 blocks away, watching that all happen.
Oh,
That's a whole
wow.
nother thing. But in any event, the other guy who lived on the top floor of the building, had the other penthouse, was a guy who owned a chain of clothing stores, like urban hip hop clothing stores,
Yeah.
did well. And he was a Jewish guy. And Matthias Goldner actually was, as it turns out, in essence, a modern day Nazi. So in December of 2001, he started putting graffiti all over his door, swastikas, references to Zyklon B, the gas that was in the camps, at Birkenhaus and wherever over there, Auschwitz and whatnot, and started doing other things. And eventually the NYPD got involved, and they put a camera in the victim's apartment, and you could actually see, through the fish lens, if you will, through because the camera was attached to the peephole, if you will, and
Yeah.
you could see Goldner doing, these things. And then one day he showed up with, and this guy was mentally ill, clearly. He
Mm.
showed up with a can of gas and some rags, and lit the apartment on fire, and went all the way up to the door, and every alarm in the building went off. And again, this is in December of 2001, right after 9/11.
Yeah.
All the alarms and sirens are going off. These people lived on the 57th floor. You know, as you can imagine, there's quite a response, this and that. So this guy ultimately gets arrested. And
Mm-hmm.
after doing a bunch of search warrants for his apartment, inside his apartment, it was Goldner's apartment.
Yeah.
It was a horror show of just anti-Semitic paraphernalia and literature like you just couldn't believe. All kinds of stuff praising bin Laden, praising the Nazis. This, I mean, a hardcore Nazi working at the United Nations. And, you know, he
Unreal.
ultimately, so he became the first indictment in New York State under the newly passed hate crime statute for arson and attempted murder, I believe, if I recall correctly, a whole bunch of other things. Eventually, he went to prison, and he was a young guy, and he ended up actually dying in prison after about 5 years. Whether it was suicide or overdose, it was never really made clear. But that was a fascinating case at a fascinating time, mostly because this city was just on edge, like you
On the
can't.
verge. Yeah.
Everything was tense, and within that time period, you know, attempting to burn out a guy in his apartment for being Jewish after what was going on with 9/11, it was pretty crazy stuff. Yeah, that
Yeah.
was a big.
Well, yeah, that was huge.
Yeah.
And then moving into your defense career, I know that you went actually to your friend, as you were saying, your foe that became a friend with the show me the money. But then you opened your own practice in 2008, as you have told us. And since then, you have had incredible cases. And
Yeah.
I know that most know about um, the grid kid or the ghetto mafia of John Juka. Is that his name?
Juka's his name. He, you know, I picked him up as a post conviction thing. So
Mm-hmm.
he was arrested for a murder that occurred in Brooklyn in 2003, very high profile case in New York. For
Mark
back
Fisher.
then, it was, you know, for several months, the biggest murder case in New York.
Mm-hmm.
Um, and back then, he was known as the Grid Kid Killer because the victim in that case was a college football player. But when I got involved, which I think was in 2012, and you know, we've gone up and down the appeals courts with him. It's been quite a ride. It's not over. It's not in a great place right now. It's not
Yeah.
over. But the best thing I can tell you about him is initially he was just known very disparagingly as the Grid Kid Killer, who allegedly belonged to this gang, Ghetto Mafia. But what he's mostly known for now is being screwed by the misconduct of a self-styled Brooklyn prosecutor who fancies herself quite a celebrity and superstar true crime personality. But the reality is this case is the stain of her career. It will remain that. Some point John will be freed, but very few people refer to him at this point, other than the tabloids, you know, as the Grid Kid Killer. He's mostly known for being wrongfully convicted. So doesn't
And
open the
there,
gate, but that's certainly progress of some sort.
yeah, and there was actually Brooklyn under the DA Hines, his office, right? That was like a nightmare for Brooklyn for a very long time. Is that accurate?
Yeah, Charles Hines was a disaster as Brooklyn DA. He was, you know, he started out, you know, he came into power the right way. He prosecuted, again, I don't know how well people know New York in the 1980s and the racial history, but the famous Howard Beach riots and
Yeah.
murder, where a kid was chased into the street and got run down on the Belt Parkway out in Howard Beach, Queens, and these
Mhm.
racists got prosecuted. And Hines was the special prosecutor in that case, did a great job, ran for Brooklyn DA, and he basically, one of the reasons why the Karen Reed case is so fascinating to me is I can't tell you how close the Brooklyn DA's office that I know from the Charles Hines DA's office resembles the Michael Morrissey Norfolk DA's office. It's uncanny. And that's one of the reasons I just find the parallels just remarkable. But Hines became one of those guys who essentially was DA for as long as he wanted to be, raised a lot of money, but never ran, opposed, collected the money, banked it. All his people donated to him. They all worshiped him. Everything you see that goes on in Norfolk County. But, maybe 15 years ago or so, the criminal justice system, certainly in New York and really nationwide, changed dramatically with a newfound appreciation for the possibility of wrongful convictions and prosecutorial misconduct. And when this started nationwide, Brooklyn under Charles Hines became the poster child of wrongful convictions. And ultimately it undid him, and he was thrown out of office in 2013. I'm always pleased to say that, many of my cases helped contribute to that, became, some of his major stories of misconduct and just corruption. And, we'll see what happens with Morrissey with this Karen Reed albatross around his neck. But John Juka was one of those poster child wrongful conviction cases. Most of these occurred in the early to mid 90s into the early 2000s. And most of these cases that were wrongful convictions involved overzealous prosecutors, not disclosing exculpatory evidence, ignoring all the red flags of actual innocence or certainly reasonable doubt. And just, it's where I came up with the term zombie prosecutor. It wasn't original with what you see in Norfolk County. The first zombie prosecutors I ever saw were in Brooklyn, New York.
Absolutely. And when did he come? When did he get out of power? When was that, Mark?
So he was tossed out in 2013.
13.
He also was the subject of a federal investigation around that time from the Eastern District of New York. Ultimately, they did not bring charges against him, but they certainly severely damaged him politically and professionally, and had a lot to do with him getting tossed out. And then, it's sad because he was not always that way.
Yeah.
I had mixed feelings about, Hines, but again, you go with the clients, you go with the people you represent, and that's your beacon, that's your North Star. You have to do what's best for them. And if you have to take on the politically powerful, even if it offends them, you have to do it. But in the beginning, it was a little embarrassing. I mean, I started in the Manhattan DA's office in my same class and was close with his daughter. She was a Manhattan DA in my class. We were very friendly.
Oh,
Not so much today, but, more important were obviously justice and clients than personal relationships. And that's what lawyers do. You're worried about doing what's right, not what's popular.
absolutely. And actually with the Juka case as well, wasn't there that the prosecutors withheld a recorded statement from, was it John Albert?
Well, they did a couple things.
Oh,
There were two jailhouse informants, which by the way, anytime a prosecutor tells you that a case is primarily based upon a jailhouse informant, that's like red flag number one.
whoa, yeah.
That's, in any event, there was a jailhouse informant. His name is John Avito, and I'll just give you the Reader's Digest version. He basically claimed he overheard a bunch of stuff and that John Juka had confessed to him various elements of the crime. And anyone who would have been paying attention would have recognized that he was screwing up details. He knew a few things, but he clearly didn't make any sense. And it had all of the indicia of your typical jailhouse informant who, and this is like in 2004. Okay. So what are they doing? They're reading newspapers. They're reading tabloids. They're watching the news. That's all. There's no internet for these guys. They're living in Rikers Island, which is hell on earth. But he was butchering details. It was obvious that he was concocting this to help himself. He ran to the cops after he violated a drug program. He was facing 3.5 to 7 years in prison. He held the information until he was in trouble himself. And then all of a sudden, as soon as he knew he was in trouble, he called the cops and said, "Hey, I have information for you." The cops, rather than arresting him as they should have, he was a fugitive. He was facing a lot of time. He should have been brought to court. Instead, what they did was bring him to the Brooklyn DA's office a day later, where he met the prosecutor who was handling, as I said, the most high-profile homicide case in New York. certainly not dealing with drug court violations of this
Yeah.
No, I mean, talk about, nothing that would be interesting otherwise. But she took his information and then she took him back to court to return on his warrant. And rather than him be jailed as he should have, she went up, she saw the judge privately at the bench, not on the record. And it turned out he was released. Obviously, you know why, because judge, he's going to be a witness in the Grid Kid case. We need him. And he was released and he ended up testifying. None of this was ever disclosed to the defense about how he met with the DA and she went to court and advocated to the judge that he's a witness and let him go. All that was concealed from the defense. And instead, this witness testified to the questioning of Juka's prosecutor that, the only reason he was cooperating with her was for once to do something right in his life, just for once. He's a good Samaritan. He's a good guy. It's a civic obligation. This is such unmitigated, unadulterated bullshit.
Yep.
It's so offensive to its core. And, when I met his mother and we started unpacking this, we found some transcripts, which again, all of this was off the record, so you don't see what's happening with the judge and the prosecutor. But the one thing we did see, which made me fell out of my chair, was seeing a transcript on this Mopes drug case the same day he violated his program. Any court transcript, as you know, is going to show who's appearing for who.
Right.
When I saw Juka's prosecutor appearing on this Mopes case, I just knew. And we found him and he met with us. He gave us sworn statements and he testified as our witness at the hearing. And he broke down with the guilt and, said he was sorry. A lot of good that does, I suppose.
Yeah.
And then there was another jailhouse informant in that case who gave a recorded statement to the same prosecutor, who basically said that the DA's theory was that, John Juka had given the gun to a co-defendant, a guy named Antonio Russo. I don't want to get too in the weeds, obviously.
Right.
This jailhouse informant had actually gone to Bellevue for a medical visit, your kind of place, Bellevue, with Antonio Russo, and they were chit-chatting as inmates do. And Russo is a thug's thug. This is a tough guy.
Yeah.
And they were they talk about their cases and this and that. Long story short, this guy told the other informant, meaning Russo told the informant that he had committed this crime on his own and that he tried to give Juka the gun after the murder, but he had refused to take it. Now, this would have been devastating to the DA's case. This was all exculpatory evidence. None of this was disclosed either. They have to understand this prosecutor later would go on TV, which she's still on today. I'm not going to say her name, but you can look it up. It's all there. You Google, people will find it. And she used to advertise herself as, I'm a Brooklyn DA and I've never lost a trial. That was her selling point. And, that kind of crap might have worked 17 or 18 years ago. But when you have a prosecutor who's marketing herself as I never lose, that's not somebody who's interested in justice. That's somebody who's interested in winning. And,
35-0 when it's people's lives, in your hands.
Literally kept score.
Yeah.
And, today, though, if you look at her marketing materials, the murder of Mark Fisher was the victim in that case. By a completely innocent victim, by the way, just the perfect
all-American boy,
that anyone would have wanted as their son. I mean, it is a tragic case, but the murder of Mark Fisher is scrubbed from her highlights because it'll just attract too much negative attention. Because there's, again, anybody who understands how this works recognizes that that's a dirty case, and that's a conviction that actually had been reversed by an appeals court and was later reversed. I mean, there's so much up and down the court system with this, and it's something that will follow and continue to work at. And again, to relate it, not really, it's substantively to the Karen Reed thing. When you get attached to these cases, you never quit, you never bail, and that's why to me, when there was all this discussion after the maybe retrial, whatever, the maybe non-verdict verdict, whatever the hell it is,
Yeah.
when people would say, oh my God, is Alan Jackson going to come back? There's no way that a lawyer who does what we do with the tunnel vision about justice that people like us have, and the amount of the way you just get into it literally becomes part of your life. The idea that a lawyer of that skill and that ability and that personality and that motivation would simply walk away struck me as never. I mean, no chance. He would never do that. So, and I'm not, then he's not, of course he's not. So,
yeah. And I just wanted to, I'll wrap up with definitely with Juka's case, but his mother, I know, was known as Mother Justice, right? Because she did incredible undercover work to do anything that she could for her son. And I looked on your website, obviously, and that it's currently in front of the board, like for review, correct? For the appeals, his case, or is that
not at the moment? Right now, it's in a refocus, recalibration. There are things happening, but these are all behind the curtain type things. But Mother Justice, Doreen, who did amazing things. I mean, she went undercover, and and it's another parallel, if you will, to Karen Reed. There was she befriended a juror, and it took her months and months. She literally, the discipline. And she recorded a juror, and after the case, obviously, and the things that he said, and I've heard those recordings. I didn't represent him during this. I came on after this, but if you heard those recordings and heard the things that juror said, anybody who believes in any semblance of justice would say, my God, this is just wrong. How do we not have a retrial? And the interesting thing is, that was not the DA's fault, but they fought like hell against a retrial. And, one was not granted because of the juror. Now, again, that's before I got involved. But in that case, the DA's office took a very aggressive position, even though a juror was clearly indicating he knew witnesses, that he hated this guy. His boss told him, you better find this guy guilty. I don't like Jewish people. Who Juka was Italian, but his name was Juka. So we thought he was Jewish. I mean, if that doesn't tell you how much of a moron
bonehead
was. But in any event, and there is a cringe video. If you want to see this juror get interviewed on TV, he was interviewed by Martin Bashir on Nightline around 2009 or 10. And if you Google Martin Bashir, the juror's name was Jason Allo, and he went public. This is not, this is not doxing a juror. This is not, Karen Reed juror. This guy went voluntarily on Nightline with Martin Bashir to express his viewpoint. So it's all public record and out there. And, as far as Doreen and the case, we went on 2020 multiple times. This was featured last year. We went to LA, went on Dr. Phil, the very last Dr. Phil episode, as it turns out. So we went out there and, spread the news on that. John's case was featured, as was another case sounds like a terrible case. I think it was in Missouri. It became particularly interesting to me because one of his advocates was actually an actor who was on the show with us from The Wire. And I love The Wire. I mean,
me too.
Yeah. The actor who played, I believe his name was Chris Partland, right? He was kind of, remember Marlo Stanfield, like the last couple seasons, like the main guy, his right-hand man. And his name is Genga, the actor. And he's the nicest guy, and he's dedicated to helping this other guy. So we hit it off out there. They featured his case. They featured John's case. So there's a lot of stuff online, and, we'll be back on John's case, but, at the moment it's not in a great place, but it's not over.
Yeah. And I also, with other parts of your defense career, right, is that, anybody who would like to pigeonhole yourself or myself as anti-police or anti the thin blue line. I'm anti the thin blue wall, babe. Okay, that's the only thing I'm anti, and I'm anti bad cops. Good cops we love, right?
Yeah. I mean, look, I've represented.
That's what. Yep.
Many law enforcement officers.
Mm-hmm.
Supervisors in the FBI, supervisors in the NYPD, prosecutors, although that's not really cops, many law enforcement, detectives, sergeants, officers, you name it. And I'm very pro police generally, but I'm also very anti bad cop. And, but some of the most interesting cases I've ever had have been representing police officers. I mean, I probably the most fascinating defense case I ever had was representing a former SSA of the FBI, a supervisory special agent, they call them, of an organized crime squad in New York City, who was accused literally of supplying a high-ranking, what they call top echelon mafia informant in the Colombo crime family. You've heard of them. One of the 5 families in New York, of providing his informant with information rather than the other way around, which led to a series of murders in the Colombo crime family in Brooklyn in the 1980s and 1990s. And the informant is one of the most well-known, notorious mafia guys of probably the last 50 years. And if anybody's like a organized crime buff, they've heard of him. Greg Scarpa was his name. He was known as the Grim Reaper. He's actually the guy, if you know the story of Mississippi Burning, Schwerner, Goodman, and Cheney, the 3, workers who were buried in Mississippi.
Yes.
And the FBI couldn't find them and they couldn't do anything. So they said, let's bring in a Brooklyn gangster thug and maybe he'll find someone. Well, the true story is the Brooklyn gangster they used was Greg Scarpa, who went down, talked to the local KKK guy who owned, I think, a television store. And within 24 hours, they found the 3 bodies because, they have a different way of doing it when you're a made guy from Brooklyn who can talk some sense to the Mississippi KKK racist asshole. So, but, so this guy, the agent was tried by the Brooklyn DA's office. Again, another amazing parallel with Karen Reed. In that case, the federal prosecutors were more than familiar with the FBI agent. He had testified in 1 million FBI in the Eastern District and Southern District of New York, famous mob trials in the 80s and 90s. The Carmine Persico case, the commission case, the pizza connection, all these big, you can look this all up, all this big time New York crazy OC stuff when Giuliani was the U.S. attorney and all that kind of stuff. And they had heard stories about, some of the gangsters saying this FBI agent is dirty, and the U.S. attorney had investigated it. And they didn't do anything with it. It just wasn't founded, so they left it alone. But when the Brooklyn DA's office came years later, this was in 2006, 2007, for murders which occurred from 1984 to 1992. They're old mafia murders. The U.S. attorney told them, don't do it. You don't know what you're doing when you get into this world of shady organized crime witnesses. They're savvy, because all the witnesses are cooperating gangsters. Okay. That's how it works. Literally in federal court. And they were told, don't do it. And the DA said, we're going forward. And that was my first introduction into a concept known as a TUI disclosure. Maybe you've heard of it.
I have.
And I've only heard of it twice in my life. One of them is a case I'm talking about that I was involved in. The other one is this one. And so the chief witness in the case against this FBI agent, whose name was DeVecchio, was Greg Scarpa's former wife, who was the most not credible witness you've ever seen, for many, many reasons. And so she had made a number of statements over the years, and other gangsters had made a number of statements over the years of information about why these people who were killed, and they gave them the legitimate reasons. It's, it's gangster shit. It's
Yeah.
not the FBI agent leaking this information to the mob. It's all kinds of reasons. We heard this guy's going to be a rat. This one got in trouble. This one's girlfriend talks too much, and that kind of stuff. And they told them, you need to turn this over to the defense as Brady material, and the Brooklyn DA didn't do it. So the Eastern District of New York, the U.S. Attorney's Office, said, then we're going to do it. And they turned over thousands of pages of stuff that clearly would have, and did, in fact, obliterate the case against Linda Vecchio. And in that case, it was so bad that in the middle of trial, during the cross-examination of this witness, the girlfriend, the case actually was dismissed in the middle of trial. They couldn't even get through her cross-examination before the DA had to wave the white flag for a number of reasons. And again, a lot of similarities with Karen Reed. And I'm actually one of those maybe fools who thought they may not even get through trial. Maybe that was my own bias from this case, but I'm not sure how they did get through this trial. I don't think they're going to get through it again, but that case was absolutely the most fascinating, that you could ever handle. I mean, you cross-examine a guy who is willing to admit in very nonchalant tones, walk through all the people he's killed and how it happened and this and that, and how I pled guilty. I went to prison for 5 years. I went into the witness protection program, and that's it. But that's why we did it. And there's no emotion. It's just
another day that ends in Y, right?
The way you go to get a pint of quarter milk, they do whatever they have to do in that life. But they all told stories that were just totally different than what the DA was offering. And what the Brooklyn DA didn't understand, and I don't think the Norfolk DA understands, is that these guys had what they call 5K1 agreements with the U.S. attorney. That's legal mumbo jumbo for substantial cooperation, which got them a huge sentencing break. So, for example, one guy in the Colombo family, he killed 5 people. He was on the run for years. They found him. He ended up cooperating. He testified in many trials, put a lot of guys away. He went to prison for 5 years, for killing multiple people, but they needed him. He put a lot of bad guys away. Everybody knows about Sammy the Bull Gravano, right?
Absolutely.
He killed 19 people, and, all things considered, didn't do that much time because, you had to do it. The point is, when they testified at the trial, they were never going to deviate from what they told the feds, because what happens when you deviate with what you tell the feds? Well, if you have a 5K, they rip it up and they put you away and you're gone. That's why, when you're looking at the current trial that just happened and all these guys are testifying, why it was clear to me, these guys don't have deals, because they would never be doing this. They would never be saying, I don't know what happened. I didn't see anyone. There's no way. They might have met with the U.S. attorney. I'm sure, well, we know some of them did.
Yeah.
But there's no way, at least as of the time of the trial, that these guys were working affirmatively with them, because it would have been suicide for them, not literally, but figuratively, for their freedom to do that and then perjure themselves. And that's another reason why during the trial, I thought it was just ridiculous from a selfish standpoint. If you were Michael Proctor, who, look, he's a monster. He's corrupt. He's the worst kind of police officer imaginable. He deserves whatever legal process happens to him. But the reality is, from a selfish standpoint, I never understood, why is this guy testifying? He should be playing ball with the feds on some level. And whatever you do, don't do anything that could be perceived to be perjurious if you're ultimately going to work with them. Also, if he doesn't testify, he keeps his job probably for another 5 or 6 months, which means he gets paid. Instead, he testifies. He probably, almost certainly perjures himself, immediately is on the process determination, loses his money, has his family going crazy publicly with all this nonsense about, help save Michael Proctor. And if he ever does play ball with the feds, the deal is going to be much worse, because look what he just did at the trial. You didn't do the right thing. You lied further. And
Amen.
there's no question that he lied about any number of things. Whether you think that he planted evidence or not, which I believe he did. I think any sane, rational person believes that, for reasons we can talk about. But he lied about other things too. I mean, when he was trying to explain his why he sent those awful, misogynist, hateful, inappropriate, whatever other adjectives you can come up with, those messages that he sent to Buchanan and others, his family, his high school friends, and all the other losers who didn't do anything about it. His excuse was, well, I was really emotional about and really upset about what happened, so I just kind of acted the fool because I was emotional. And there were really two problems with that story. Number one is, buddy, some of those messages were 8 months later. So number one, get over it. Okay. Maybe you're cut out, you're not cut out for this line of work. I mean, nobody believes that. But more importantly, without any disrespect to what happened to John O'Keefe, because, somebody dying is somebody dying. It's awful. If you are a homicide investigator, though, and you can talk to any homicide detective, I know a million of them. Some of them are in private practice now. I know them as investigators. I know them as detectives. They're a different breed. Okay. They have to disassociate. They have to be unemotional, but there are times where they're human beings. It gets to you. Now, this is going to sound terrible, but hear me out on this.
Yeah.
If you're investigating what may be a murder, a hit and run, okay, is not going to be the one that is going to do that. It's not going to make you lose your shit. So
your composure, right?
It's
Yeah.
going to make you, again, the kind of thing that's going to get to you is, a 7-year-old girl walking down the street who gets picked up and chopped up into bits by that is going to make, if anything. But according to Proctor, he said, I was so upset. I was so emotional. And it left me with two thoughts. Number one, that's just not true. But number two, let's play this out and assume it is true. If that upset you, how do all these other cases you handle not upset you? And if they do, does that mean there's others in other cases? You have that Brian Walsh case, the one everyone knows about, that horrible one. That's a perfect example. That's the kind of case that's going to make you, I mean, that's a sick case. I mean, that's a guy who, was Googling, presumably, how do I chop up my wife? How long for this? How do I do this?
125 pounds. Yup. And everything.
I mean, and, he was a fraudster, as everyone knows. And, she's never even been found, and all of that. And the other thing is this, the murder victim in that case, she was attractive. She was like a young, successful real estate agent.
Beautiful.
And what's the point of that? The point of that is, do you think Michael Proctor is looking for nudes in her phone? Or do you think he's sharing stuff with his buddy about that case? Now, I don't know the answer to that, but I'll tell you something. I'd say the odds are on the better part of 50%. And others, you don't think he's going to talk to his high school buddies about that?
His 9 friends from high school that he couldn't shut up talking to the day of Officer John O'Keefe's death. Like, it's unreal what he was providing to civilians.
Or well, maybe not civilians. What did he tell Yuri Buchanan? I don't know. Maybe nothing. But he told him about all this nasty Karen Reed stuff. And Yuri liked it. Or at least some of it, right? Didn't he like some of these posts or whatever you call it?
For the reaction, he did, yes.
Well.
And it was more criminal, though, Mark, if we look at it, right? When I hear him with trying to, as much as the medical examiner, Dr. Scorti Bello, said that she didn't feel pressured, she's full of shit. And we appreciate her because she recanted what she said about there being no signs of any altercation or fight, and she walked that back. But at the end of the day, they realistically went in there twice to her,
They bullied
provided all the information they had, and still couldn't get her to say it was a homicide.
Listen, what happened in the Karen Reed case investigatively, whether, and we're not even talking about like solo cups, leaf blowers, and that kind of stuff, are not securing crime scenes and not interviewing people separately and properly. I mean, you could go on, and I could put you in touch with, a million cops I know in the NYPD who are just appalled by this. Current active duty, high ranking guys, crime scene guys who just want to throw up at the way this was all handled. But everything about this case was so bad. But the idea that they had to attempt to bully the medical examiner to even call this a homicide, and a homicide is not even necessarily a meaningful thing about guilt or innocence. I mean, that's just a legal forensics term about, as you know, somebody causing the death of another person. I mean, there could be justifiable homicide. It may not even be a crime, but it just means it was caused by someone else. It's an unnatural death caused by somebody else. And they couldn't even get that from her, which is telling in its own right. And, I always thought that, at least from a trial standpoint, that it's almost like people buried the lead about the text. Obviously, the text about the disgusting misogyny, about the nudes, about Karen Reed's health and her physical ailments or whatever, and how much we hate her. And that was always going to get the attention because that's just so shockingly gross. But from a legal standpoint, I always thought the most significant text were these knuckleheads talking amongst themselves, talking about how we're going to bully the ME and jam this down her throat and get what we need to get the classification we need. And if you know the case, this is at the time that they were planning on indicting her, and they wanted a murder indictment because they knew she wasn't going to, cop out, and they wanted that plea. And all they were doing is saying, essentially, what do we do to get this ME to say what we need? And, it's just when knucklehead cops are interfering in the science, as you would know, I mean, you're part of the scientific process, are interfering with the scientific process and trying to influence and bully, threaten, intimidate, whatever you want to call it, it's becoming less and less scientific and more biased. And there's so much investigative bias that was associated in the Karen Reed case, both with the medical professionals, both, again, with Proctor initially. I mean, one of the other things that Michael Proctor did, if you recall, was say, I thought this was a car accident right away because, he was lying in the yard 30 feet away with one shoe on. I mean, this is like a cartoon, that testimony.
Exactly.
That's why you think that's a car accident, because, Jennifer McCabe said something, she may have hit him. And, based on the car accidents, I know because he had one shoe. I suppose you could say that's a possibility, but, you don't think it's a possibility that he, I don't know, took a shoe off inside, or it fell off in a struggle, and, you're not curious. But then, one of the most, what I thought, interesting pieces of testimony was that I thought they left on the table, to be honest, in the summation, but they'll fix this because these guys are the best of the best.
Yeah.
Proctor was vigorously cross-examined and really effectively by Alan Jackson about, you had your mind made up and you weren't interested. And Proctor was trying to say, I'm just following the evidence, and it wasn't tunnel vision. I had evidence.
Yeah.
And this guy, if there's anything you need to know about how awful a police officer he was, and this has nothing to do with the corruption part of it, nothing to do with the text messages, this guy ordered a tow truck to tow the vehicle that he just assumed had to be the instrumentality of death before he spoke to Karen, before he looked at the vehicle, before he did anything. And then when he got down there, the vehicle was staring at them right in the face. It wasn't concealed. It wasn't hidden, notwithstanding their argument that she tried to demonstrate consciousness of guilt. The vehicle was at her father's house right there.
Of course.
Wasn't even turned around. The taillight was staring at them in the face. Put aside the testimony of the local cop, who was a good witness.
Of course.
This guy, this ace
Bederow.
homicide investigator, what's the one thing he never did? He never walked up to the frickin' taillight with his iPhone and took a frickin' picture.
I don't know. Can you explain to me, though, Mark, how they even got that warrant to seize her vehicle? Because no taillight was found.
Listen, based on in all fairness, even today, I'm not that familiar with the year of pretrial stuff, other than I know some of it in working backwards, but I don't know what happened pretrial in terms of motions to suppress evidence, specifically her cell phone and whatever was contained on it, the vehicle, and what was obviously contained on it and in it. But the testimony at the trial was shocking, because the testimony was, I just went down, I ordered the tow truck, and I told her, we're taking it. Not with a warrant, I'm just taking it. And, most places in America, there's still a constitution, there's still a Bill of Rights, there's still due process, there's still
that thing, that
nasty, nasty thing that a lot of prosecutors hate, that's known as the Fourth Amendment, and unreasonable searches and seizures, and the requirement of probable cause, and this and that. The testimony from, as I recall it, and if I'm wrong, someone can correct me, from Proctor and Buchanan was, we're taking the car, and that's that. The testimony about the phone was, we're taking the phone, and that's that. And, the testimony, as I recall, it was almost like Proctor was almost like looking over her shoulder to see, what her passcode might have been, or he obviously accessed the phone. And the question becomes, how did he do that? Did he force her to tell the password? Did she volunteer it? One thing I didn't hear in either one of their testimony was seeking consent, which is always the easiest way around a probable cause or warrant requirement. Ms. Reed, do you mind if we take the car? No. Okay, done. Legally, it's over. Do you mind if I look through your phone? I don't recall any testimony about that. I just recall these guys ordering a tow truck before they ever saw anything, going down there, not even looking at the vehicle, not doing anything, hearing her give some form of an explanation, which they found suspicious apparently, and then all of a sudden said, we're taking the car and the phone. And during the trial, I almost fell out of my chair, and admittedly, New York's a different place, thinking, what the hell happened at the pretrial motion to suppress, and how is any of this admissible? And you have to understand the significance of this. If that car were suppressed as the fruit of an unlawful search, it's out. If the car is out, the photos of the taillight are out, okay?
Well,
the so-called hair on the car is out. The so-called glass on the car is out of the case. Her phone is out. All of the stuff that although they might have gotten it from John O'Keefe's anyway, and so I don't know how that happened, whether it happened, what it is. All I know is, in listening to the trial testimony, I was shocked out of my mind that this was not a big deal in this trial. Now, there may be reasons for that. And again, I'm not second guessing anyone, because I don't know what happened before. But the testimony of those two guys was stunning in terms of how they just decided, we're taking the car, we're taking the phone. I mean, this feels...
Well, and to just talk about that bias, though, Mark, right? Of, we're taking this car, we're seizing this car, we're seizing this phone without a warrant, but we're not even going to ask Brian Albert at 34 Fairview to go into that house and look around.
Well, I think we have theories about why that may be.
Well,
I mean,
yes,
somebody had to be the patsy. But in terms of the mechanism of just, we're taking the car, we're taking the phone. The scary thing is, that's not unique. That's investigative muscle memory for these guys. This is probably what they do all the time. I'm the cops. This is what we're doing. Here's how we do it. And, most people are going to yield to the power of the law. And certainly at this time, on top of everything else, what kind of condition was Karen Reed in? I mean, as fragile gets, right? I mean, she's basically
Oh,
curled up a ball on her parents' couch, whether you believe that or not. I mean, some of
I
these
do.
people, everything they want to think is unfair, it's a lie, it's a scam, it's all part of the cover up. She backed into John O'Keefe's car, that's a cover up. Then she left all these messages, that's all the cover up. She faked the tears, she faked the lunacy. It's all, calling him, I hate you and this, because naturally that's a way to, make it look like you didn't kill someone, to send them messages and say, I hate you. I hate you. I mean, who does this? But the way the cops handle this case is terrible. And it's at every level of law enforcement. It was the Canton police. It was the state police. It's the DA's office. And you can't ignore the fact, and this is the biggest thing to me, it's the death of a brother officer. And anywhere else other than apparently Canton, Massachusetts, Norfolk County, I guess on a larger scale, when a police officer is down, and I know this from experience, and unfortunately we see this a lot in New York City. I mean, 3 days ago, 2 cops got shot breaking up a robbery in lower Manhattan, which is,
Right.
that's not supposed to happen in Manhattan, and it does more and more. In any event, in most normal jurisdictions, when a good cop is killed, whether off duty or on duty, and by all accounts, John O'Keefe was a good cop and a good man, right? No one had any
Yeah.
problem with him. It is all hands on deck, like nothing you've ever seen. And one thing that doesn't stop that is a few inches of rapidly falling snow.
No.
But in Canton, I think perhaps the most shocking testimony you might have heard in the entire trial, literally bar none, I think it was Lank. I could be wrong. It's one of those guys in the early part. And I don't go back and reread the testimony. I've just got other stuff to do, but I
Yeah,
remember
of
this.
course.
I don't know who it was, but he said, I called the state police and said, what do you want us to do? You want us to hold the scene? And they were like, we're not sending anyone. And this was around 7:30 or 8 o'clock in the morning,
Yeah.
which means this is about approximately 2 hours after they found John O'Keefe. All law enforcement, the Canton police, Massachusetts State Police, literally abandoned the crime scene. Literally abandoned it. And at that point, once they abandoned the crime scene, every piece of forensic evidence at that scene is potentially tainted. You've lost control of the crime scene. You've lost
By
control
definition.
of the
Yeah.
chain of custody, but you've also enabled something else. You've enabled the possibility and opportunity for dirty cops, if they do want to sprinkle a little taillight, to do it. Now, if that crime scene was held by honest, earnest cops, as it should have been, well, that's not going to happen. I mean, if
Right.
you have the perimeter of the scene secure and you
Yeah.
have legitimate, honest cops there, that can't happen, which also
Mhm.
would have been a good thing for the DA, because if Karen Reed were in fact guilty, which I don't believe she is, but let's just play that out for a minute. If she were in fact guilty and the crime scene was secured properly by honest people,
Mhm.
and they found all that taillight exactly where they found it, well, guess what? That's bad for the defense. That's
We would
not
have nothing to say.
explainable. And I
Exactly.
don't think we're even having this conversation today. So that abandoning of the crime scene, whether she's guilty or innocent, is a complete disaster.
100%. And while we're on that, I was wondering so we got was it yesterday? I don't even know. What day is it? No, Friday. We got the DA, the response letter from the meatball Morrissey himself, who I like to say is just one sneeze away from a cardiac event. It makes me very medically uncomfortable to sometimes see him. But what is the thought process on having it take them weeks to respond after they had been outreached by jurors,
That's
Mark?
easy. That's easy. They got smoked out of their cave by working
Christina.
media. That's right.
Uh-huh.
And another red flag of a DA's office that is either incompetent, unjust, or even corrupt, which, you draw your own conclusion. Another
Mhm.
red flag is what gets them to operate, what motivates them. And in Norfolk County, it's the press that motivates them. That's what makes them move, react, and do things. Okay. And you've known this for some time, even before you get to what happened last week. Last summer, almost a year, almost to the day, I think, you saw Michael Morrissey do one of the most
Unprecedented.
unethical
Yep.
things. I mean, I'm talking now, I don't want to get too into the weeds as a lawyer, for a sitting district attorney on an open murder case to give a press conference in the manner that he did and mention the things that he mentioned, made a mockery of what every lawyer knows who tries cases and does litigation, is something known as, Rule 3.6, which is pretrial publicity. Okay.
Mhm.
And there are certain things that you can mention and certain things you can't mention. And you can't mention the strength of the case against a defendant. You can't mention or vouch for the credibility of prosecution witnesses. You can't talk about, scientific evidence. You can't basically say why we believe this woman is guilty. And he checked off every single box, essentially, of the things that you're not able to say. And in essence, gave what appeared to sound not a district attorney's speech, but as a paid advocate for certain members of the Albert and McCabe families. Now, it might have been appropriate for the law. And by the way, all of these people had lawyers. All the
Yeah.
Alberts and McCabe's had lawyers. And if I had been one of their lawyers, I might have given a statement saying, leave them alone. They shouldn't be harassed. And there's nothing wrong with saying you shouldn't you shouldn't harass witnesses. Okay.
Don't do it. Yeah.
Right. But for the DA to ostensibly pass a message about don't harass witnesses and turn it into that charade, I mean, it felt like a hostage video. I mean, it just completely felt like he was being forced to do it on behalf of these people, and it was completely inappropriate. But the point is, they were getting bad press at the time. Okay. This is a few months after that, dramatic defense motion for the phone records of all these people, the Google searches. Now we think that the Albert.
Yeah.
So what does the DA do? They give an unethical public statement to push back. Fast forward now. Okay. When the defense filed the affidavits in this case related to the jurors, which is something that no one's ever heard of, getting contacted directly by jurors who say, we actually meant to acquit and we all feel that way. And they just keep calling and keep calling and keep calling. You have to start with the DA's initial response. Their initial response was condescending, dismissive, they're unethical. But more importantly, what did they say? Besides the legal arguments about the waiver, about, you should have said something, which is a whole nother conversation. They said, this is unfounded. There's no evidence of this. In other words, this is all bullshit. Okay.
Colin was not in the house. Colin Albert was not in the house. Affirmative, statement, period, point blank.
Right. Or Proctor has no relationship with these people.
Yes, absolutely.
But bringing it back to the juror issue. So they submit a response that basically says there's no merit to any of this. Mm-hmm. It's unfounded. And then you find out a few days later, and I thought this was going to happen, by the way. I said, this is really disrespectful to jurors who dedicated 2 months of blood, sweat, and tears to this. The result is what it is or isn't. We don't even officially know. It's disappointing if you're a juror that the case ends in the way it did. You reach out, and the DA's response basically is, we don't need to hear from the jury. It doesn't matter what they say. And in so many words, they're dumb, because if they meant to acquit, then fill out the form, you morons. That's how it appeared what they were saying. And then they're basically saying that the defense allegations are unfounded which is a roundabout way of saying either, Jackson and Yannetti are lying. And let me tell you something, real lawyers don't need to submit false affidavits, okay? These guys do well beyond this case, have reputations that are way up here. They're not submitting, fugazi affidavits to push this issue because they don't like, it's going to be a retrial, okay? So it was real. You may not like it, but they're not lying. And then a few days later, as you might expect, what happens? The jurors start calling the DA and start saying it's true. And what does the DA do? They do nothing. They sit on it for 2 weeks. And then they, it turns out the only thing they only did was tell the jury, well, I can't tell you that this will be, anonymous. Knowing from the affidavits that were submitted by the defense and in fact by one juror on their own, that these people are understandably very nervous about being outed publicly. Okay. So they tell them it may not be anonymous. And then a funny thing happened. The jurors, they don't call back. Now, but to get to your point is, so this happens like in mid-July and they sit on it. They don't do anything. And then Christina Rex comes out with these stories. And then the dam finally breaks when she says they're not even responding.
Yes.
Okay. And then lo and behold, here comes the Norfolk DA office with this disclosure about all of this. But again, what made them do it? What made them do it? Bad press.
Yeah.
That's it.
Yeah.
That's the only reason.
Yeah, that's wild to me. Of course, we don't expect anything else, right? Every day you think it couldn't get any more as the jurors' world turns, I call it, right? It's like a soap opera that is going around, but the fact that the Norfolk DA's office is conducting this kind of behavior and utilizing these tactics, for me, makes it seem more evident than ever, Mark, that the defense is winning, right? Like more evident than ever.
They're winning no matter what happens, because here's the thing. First of all, well, as I say, they're playing chess and the DA is playing checkers. If the DA wants, either way, there's going to be a retrial on count 2 because that was hung, like for real. I don't think anybody disputes that. So even if counts 1 and 3 were to go away, they have a legal right to retry Karen Reed for manslaughter and the lesser offenses associated with that. So if you accept that, the defense makes this motion. If the motion's granted, everybody knows, and you just got rid of counts 1 and 3. That's good. If the motion is not granted, everybody still knows that the jury acquitted her on these 2 counts. And if you want to put, form over substance and argue, well, they didn't fill out the slip and it wasn't entered, in the real world, it doesn't matter. Everybody knows. And when I say everybody, the people who know are potential jurors on a retrial. Okay. Yeah. And now imagine the DA wants to retry her on a murder case, knowing everything in the news now that she was acquitted of murder. So you've either got that out there, or maybe for once, because the DA has terrible instincts and just, their PR and their instincts are generally off. If you should turn left, they seem to turn right, and vice versa. Whatever the verdict or not verdict was on the murder count, this was never a murder case. And in many ways, they're giving you a gift. Okay. The DA right now should step up and say, you know what? We're dismissing murder. Don't even have to address this. And some will say, oh my God, they're so reasonable. And now they're avoiding the embarrassment. They look like the good guy to some, and that's that. But you just, they don't seem to have that wherewithal. And, the irony is, if they fight this and they win, it's like a Pyrrhic victory for them, because you shouldn't be trying her for murder anyway. whether the verdict should have been entered, the not guilty verdict or not. And the judge would be doing you a favor by dismissing the murder count, because you wipe out all of these meaningless witnesses who don't matter. You turn them all out. You don't have this
Tear
nonsense
it down. Yeah.
Aruba. You don't have detectives testifying that, I interviewed witnesses 50 miles away who were in Aruba before I interviewed witnesses who were inside 34 Fairview Road. I mean, that's not good. You get rid of all these kind of stupid messages from Karen Reed's phone, which do not help the DA. Okay. Having her get angrier and then turn to like, where are you? I'm not sure how they think that helps them in a murder case. So, in some sense, the best thing that could happen is somebody makes the decision for them, because they just seem to lack the wherewithal to make the decision themselves.
Yeah. No, absolutely. Now, in the letter or in their filing that they sent back, the DA's office, right? They said that there was what was the actual verbiage? That they were unethically able to discuss jury deliberations, correct?
Yeah. Once again,
go for it, Mark.
2 points on that. Number one, that's an attempt to throw some shade on the defense and imply that what they've been doing is unethical. But again, that's a complete cop-out, and they're making an argument that just lacks any credibility. I mean, they're not supposed to grill jurors about the deliberative process. They're not supposed to say, well, why did you do this? Why did you vote this? How did this happen? Tell us how. Okay. But the issue of what the verdict was, that's a result. I'm not asking you what led you to get that. I'm asking you a straightforward, neutral fact. Did you acquit, or did you find, this 9-3, 6-6?
Correct.
Whatever. That's the relevant issue. The relevant issue is not tell us how you got there. And that's the deliberative process. But the fact of the matter is, for a prosecutor to get contacted by the jury and say, we're not allowed to talk to you about what that was, at the risk of a woman's double jeopardy rights being violated, to the ridiculous possibility that she could be acquitted for murder and then retried for murder. I mean, that's the most un-American thing imaginable, right? I got acquitted and then retried and sent to prison for the rest of my life. But something else is missing from the DA's papers, which is unbelievable, and also speaks to, I think, the integrity behind their response. If you feel so ethically compromised to get to the bottom of the issue, then why not contact the court and say, can we get the parties together and figure this out, how to make this happen? Does the judge need to be involved in that? How do we do this? Because this is important. But their response is, like the three monkeys. They hear no evil, they see no evil, they speak no evil. I don't want to know, go away. And by the way, this may not be anonymous. So, keep that in mind. So their response, when you look at it from, every angle, is pretty unimpressive.
Well, and I found actually a case out of our Commonwealth of Massachusetts, right? That actually this unprecedented step of calling jurors back a year after their trial has already been done, right? So you don't have to look back that far. It was the homicide of Krista Worthington. Anyone remember down in Truro?
Yeah, I do know.
Yeah, down in Truro, right? So that was
the handyman or the garbage man.
The garbage man, yes. Yeah, so that was Christopher McGowan. Look at you still remembering, even when you're in New York, you're still watching.
Oh no, the woman on Cape Cod by the garbage. You remember that?
Of course. So, but it was the Honorable Judge Gary Nickerson of Barnstable Superior Court called the jury in a year later after the trial. So this was the trial was in 2006, and they were jury deliberations in November. But he called in 7 of 14 jurors to discuss. They called in one by one, and there was question of any racial components with if there was any bias, right, in their verdict, because he was convicted on that first degree murder. And the judge went above and beyond, though, and they said it was like historic at the time. But I feel like we would have in the Karen Reed trial, I understand a bias of race is something to 100% look into. And there was 3 affidavits that were composed by the lawyer, Robert George, and he sent them in, and that judge, in my opinion, did the right thing, right? Called
Yeah.
everybody in, had this go through some sort of legal avenue, right? To like, let's at least have this hearing. And it also blew my mind because I forgot this was a very, it was a high profile case, Mark, but they were also not sequestered, that jury, during the actual trial, but during deliberations, they became sequestered because the judge had discretion to do so, because one of the jurors, like her husband or boyfriend, ended up getting arrested for something completely non-related, but there was a concern of the media. Now, I question to you, moving forward to the retrial, if there's a retrial, would it behoove Judge Cannoni to sequester a jury, and would it make sense to look for a different venue?
Well, a couple things. First thing about like bringing the jurors back, this case is worse than that.
Yes.
For the simple reason, the jurors contacted the defense within 24 to 48 hours, 3 or 4 of them independently, without speaking to the other ones about doing it. That is, in my experience, unprecedented. I've never heard of anything like that. I mean, I've heard of, in New York, there's nothing improper about talking to jurors after a trial, or even after, a week later, sending an investigator if they're willing, and, they tell you something and here comes an affidavit, you allege something, whatever. But never have I seen it the other way, for them to literally come back. As far as, a new venue, this case is like bizarro world. So putting aside the trolls, and there's a lot of them, but there's not as many as you think. They're just very loud. They're very obnoxious. They're very delusional. They're very angry, and they're just repetitive and loud. So their numbers seem high. The point is this: the majority of people, I mean, look what happened today with these like standouts and all this.
Yes.
I mean, let's be clear. She's charged with murdering or killing a Boston police officer by mowing him down, leaving him to die in the cold, freezing to death. This gruesome, horrible last hour, 2 hours of his life, and then, maliciously attacking these innocent, good people of, the town. You would think that Karen Reed would be considered one of the most vile, hated,
pariah. Yeah.
criminal defendants, not like, on a Charles Manson level, but close. Okay. But the reality is, the public, certainly in Massachusetts, and more particularly Norfolk County, I assume, overwhelmingly supports her, or at least believes that she's getting framed, or at least believes, if you don't want to go that far, that the evidence does not support her guilt beyond a reasonable doubt. So if you're the defense, even though it's crazy out there, do you want to change venue?
Yeah.
Probably not, except, well, there are a few arguments. You want to get out of the building, you want the DA to travel the same way you have to travel, that could be, make them uncomfortable. But I'm not so sure you want to take it out of there, because you're at where it all happens. And look what goes on outside the courthouse. The support is overwhelming for her. So I'm not sure. And by January, it was hard enough picking a jury the first time. Now, now the people that are watching all the news, watching all these streams, watching everything, seeing these motions and all this going on, these are prospective jurors. Okay, good luck picking a second jury who doesn't know that Karen Reed was acquitted, that there's, evidence that Jennifer McCabe Googled at this time, that there are these witnesses who have scientific degrees longer than both of our arms put together, and engineering degrees and masters of kinetics and this and that, all of that, that the case stinks, that, the lead investigator by January will have been terminated and is corrupt and disgusting. His supervisor is under investigation. His supervisor is under investigation. You could go on and on and on with this stuff. I'm not so sure they want to change venue. Now, some of the interesting people who consider themselves analysts have said, well, the DA should ask for a change of venue. That was, Coffin Daffer's big suggestion, but that it doesn't work that way. Okay.
Right.
You are the elected DA of Norfolk County. You are entrusted by the citizens of Norfolk County. Okay. If your position as the DA of Norfolk County is that I, as the prosecutor, cannot get a fair trial in my home court from the people who elected me because everyone thinks she's not guilty, then you should have two options, Mr. Morrissey. Number one, dismiss the case immediately. Two, resign. Okay. Put in another way, the Norfolk DA is not seeking a change of venue. That is political suicide for them to do that. We don't trust the people that elected me to be able to try this case because everybody thinks everybody thinks my case is stupid and she's not guilty. So I think realistically, everyone's going to hold their nose and you're going to be back in Norfolk County, I think.
Absolutely.
I don't think it makes sense for the defense to move. Now, even if they did, the other problem they would have is where in Massachusetts, I mean, it's the same media market, except maybe like Springfield.
Yeah, Berkshire's would be the only place you might be able to, but like you're saying, why? And especially with
one reason, because then Adam Lally and his partner and the rest of them can live in a hotel too and get out of their comfort zone. That's the only reason. But that's not a reason to do it. But, obviously, Jackson, his partner, Liza Little and Yannetti, they're traveling to come to court every day. It's a whole to do. And trying cases is hard when you're the defense and you have to travel. I mean, I had a 2-month trial that was just in Queens, and it's a schlep, and it's, it's tiring where, you're not in your home court per se, but that's not a reason to get away from a jury pool that appears to overwhelmingly favor you. And the other thing is, even if you made a change of venue, you generally need statistics. You have to do polling, and the polling, I don't think, would support a change of venue. I mean, you would want statistics that say, 85% of the people in Norfolk County have already made up their mind that Karen Reed is guilty and she can't get a fair trial. The reality is, if you do that push polling, it's going to be 85% of the people in Norfolk County think she's not guilty.
Right.
So your argument is kind of,
counterintuitive. Yes, absolutely. Right. Absolutely. Now, could you just, for all of us, Mark, and then I will let you go because I have taken a lot of your time and I appreciate you so much. But I was wondering if you could maybe break down for us how our new teammate, Marty, how do we think Marty's going to do on Friday? I'm feeling slightly optimistic because it's not Mr. Yannetti or Mr. Jackson. And we know that Bev can't fix her face when, she's in front of them and she likes to huff and puff. So do you think with Marty that there will be a different approach with our appellate lawyer?
Yeah. Well, for a couple of reasons. I mean, I don't know him, but I looked him up and I know people who know him, and, he's, an icon locally of Massachusetts criminal bar. As they say, his reputation precedes him. He's been around, stellar appellate and legal credentials, and the judge will absolutely knows who he is. And I have no doubt will treat him with a form of reverence. Not that means she's going to, do what he says, but she will be peaches and cream with him for sure. Now, what does that mean? Nothing other than it'll be a different tone. I mean, I think it's pretty clear that she didn't really seem to get along with Alan Jackson and David Yannetti, but they handled it well and
Oh, of course.
whatever. I mean, they're professionals. You deal with the judge you get, you move on. But he certainly has the chops. I mean, he was brought there for the legal argument, obviously. And I think he was brought there too in case the possibility that the two lawyers become witnesses, which if there were a hearing and there are going to be jurors who testify, you probably would have Alan and David testify as well because they were contacted. You know, these people made statements to them. You want to confirm that they didn't reach out to the jurors, you know, that they contacted them. You want to establish all that. So he's brought in for the legal component of this. And, you know, he certainly has the legal chops.
Oh, yeah.
You know, and I say this most respectfully to the people on the other table in the courtroom, but, you know, they're a little, you know, outclassed here in a legal sense. I mean, this guy knows his stuff. Now, does that mean that they win? No, but I have no doubt that his argument will be as strong as anyone can make it as it relates to the issue. And also, I assume it will be very persuasive and passionate because it's not all law. I mean, obviously, the law dictates what should happen with the hearing, but you need a lot of passion in this argument. You got to do the right thing here. I mean, there is a more than likely chance at this point, in fact, almost certain, based on what you're hearing, that these jurors acquitted her of murder. Now, whether they should have filled out the slip or not, and whether somebody from the defense side should have jumped up and down and said, we don't consent to this, fair points, but they ought to be litigated. But you ought to find out, did these jurors acquit her? Because I don't know how anyone in good conscience can say that's okay to just say, let's now retry her. And the other reason is this is really important because if it turns out the evidence overwhelmingly supports from the jurors that they did acquit her on 2 counts, make the DA get up there with a straight face and say, I don't care. They didn't check off the box. They should have stood up. Let's go again with form over substance. Who cares about her double jeopardy rights? And if they do that, the criticism on them, if you think it's been bad now, it'll increase
That's a
tenfold.
media storm that they do not want to get involved in. And it's not doing justice, right? You're supposed to do justice, and that's not in the interest for the victim, for his family, for our defendant, Karen Reed, her family, and it's just horrific on the part of the Commonwealth of Massachusetts.
Yeah. I mean, I don't have a problem if the DA's attitude is we're agnostic at this point about whether they acquitted her or not. It would be disingenuous for them now to say there's no evidence. Clearly, there's evidence. But if they want to say, but until it gets fleshed out, I don't know if it happened. If it turns out that 12 jurors come in and testify anonymously, however you do it, and say, look, we acquitted, we didn't fill out the form because we were confused, Your Honor, no disrespect, but your instructions were kind of a mess. We didn't know what we were supposed to do. I don't know how at that point, I don't care what the legal arguments are that the DA has in their bag of tricks. I don't know how they look at the court, look at the defendant, look at the public, look at the voters of Norfolk County with a straight face and say, we're okay with this. At some point, you have to do the right thing, law notwithstanding. And if they think that she was acquitted, but something happened on a technicality that prevents that acquittal from being entered because somebody didn't check a box, that they're okay with retrying her on murder, then they're in the wrong business because that's not seeking justice.
Help us all, right? Yeah.
And that would put pressure on them. And I think you would actually see at that point other people of prominence, whether they be political or whatnot, start heavily criticizing the DA, saying, how can you do this? I mean, how can you literally, how do you look in the mirror? How do you sleep at night? And don't underestimate something else too. If they don't address this, these jurors, think of the slap in the face to them it is that if the judge and or DA says, we don't want to hear from you, it doesn't matter, you didn't check the box out, there's no one else for them to talk to other than the press. And they probably will, because for one really important reason, other than the disrespect they've gotten, to clear their conscience. Because how would you feel if you were one of the 12 jurors who acquitted someone of a murder charge, and you, honest to God, acquitted, and all 12 men and women are unified, we acquitted, and the DA, the judge, whoever is saying, I don't want to hear this, and then they retry her for murder. Can you imagine listening to that opening statement and
No.
being a juror from the first trial and saying, oh my God, this woman could be convicted when we already acquitted her? And the judge told us, if you remember, during their Tui Rodriguez charge, no one can ever adjudicate this case on this planet better than you 12.
You can't. Yes.
You told us that before, but after, as soon as it's done and nobody wants to deal with this, no one wants to hear with it, just throw them out with yesterday's garbage. And if you're one of those jurors, and God forbid she does get convicted when you all acquitted, I'd hate to have that on my conscience.
Yeah,
I don't think
and they probably can't sleep at night. You know what I mean? Like they're probably this is probably weighing on these 12 jurors. Like you can't even probably compute it, right? That they believed that 1 and 3 was all set and that they were just hung up on count 2 and a lesser included at that, right?
You know it's bothering them for the simple fact that there is this virtually unprecedented step that they are reaching out within a matter of days on their own, calling the defense, some of them even calling the DA saying, we acquitted. We acquitted.
Yeah.
We acquitted. Like, well, why didn't you check off the box? Well, they don't have it. They explained to the defense. The DA's attitude is, don't tell me because I don't want to hear about your deliberations. Form over substance. Everything they do is form over substance. They should be concerned as, they're supposed to be ministers of justice. They wear the white hat. They're supposed to seek truth first and foremost. A lot of times that's convicting someone of a terrible crime. But first and foremost, you have to do justice and do it right and do it fairly with the respect of the Constitution. And they seem to have literally zero care in the world or regard for the fact that they are advocating a position which may result in an acquitted woman being convicted at a retrial, which is something that one would only think might have happened in like Stalin's Soviet Union, not in Norfolk County, Massachusetts in 2024.
So anti-American and anti-constitutional rights. And it's just, it shouldn't happen. So it's not going to, because we've got to hope that Judge Cannoni listens. What do you think? What do you think is the outcome? Have you changed your mind at all after seeing the Commonwealth's response?
Slightly. I mean, only slightly, because the DA has put her in a bad position. They took an initial approach, a very cavalier, nonchalant, this is all nonsense. Don't even give this the time of day. And then again, something happened. Those articles came out, and now they've kind of sheepishly submitted this one page, what they call notice of disclosure, which is very interesting how they call that document a notice of disclosure. It's almost an admission. We feel ethically obligated to tell you, as if they're acknowledging this is bad for us. We don't want to do this, but we feel, because they're wrapping themselves up in ethics again, that we feel ethically obligated to disclose this fact to the court. So this puts a lot of pressure on the judge, because to deny it on oral argument on the papers, as they say, without hearing from the jurors, after both sides now agree that jurors have come forward with this, there's such an easy solution here in the short term. I don't have to grant the motion. I'm going to have a hearing. That's all. Bring them in. And then we'll go from there. And Mr. Lally, if you want to make your argument that they waived it, be my guest. But let the safe thing for the judge to do is say, what I thought should have been done the minute this came up, flesh this out. Don't have to don't make a decision. Get the evidence out there and go from there, and then let the parties make their arguments. So I think the odds are slightly higher that she takes that safer course of action, because there is no longer a literal factual dispute, that there is some degree of evidence that, as crazy as it sounds, that this woman was acquitted on 2 of the 3 counts.
Absolutely. Well, I'm gonna stop on that note, and I'm gonna take that with me to the bank, and I'm gonna cash that check in. And I am so unbelievably grateful for your time tonight, Mr. Mark Bederow, my friend, attorney Mr. Mark Bederow, who I said that I might ask for 30 minutes of your time tonight, and somehow you gave me an hour and a half. I very much appreciate you.
That's okay. It's not my bedtime yet. It's only 8:30. I'm good.
Not yet. Not
yet.
yeah. Well, and I hope, listen, and I'm no pressure, but if I were to ever invite you back, do you think you might join me?
Of course.
No matter what those haters said about me.
Listen, it is what it is,
And we don't listen. And
No.
you still like Nurse Kim.
I still like Nurse Kim, and as the man said in the famous movie, this is the business we've chosen. It is what it is. Practicing this kind of law for a living in the big city gives you very sharp elbows, and it also teaches you how to absorb a lot of sharp elbows coming from other people. So if the worst thing that you get are a bunch of online wackadoos who get so triggered because you have a difference of opinion about a criminal case, that's delusional to me. And what they ought to do is log off, go out, smell the roses, get a life. I would pay it no mind.
Absolutely. And please take this of no disrespect, Mr. Bederow, but because it has happened and my co-host David Cullinane has insisted I call you Law Daddy as you leave. And thank you, Law Daddy, for the best first show I could have asked for. I appreciate you.
All right. It's fun. Glad to help.
Bye, Mark. What did we just do, guys? Okay. I know that this was the maiden voyage. I apologize heavily for, not being able to answer any chats because I was just trying to ask the questions of my interviewee. And I am so thankful for Mr. Mark Bederow coming on my maiden inaugural show of Nurse Kim YouTube. Also, guys, sidebar, I have to tell you one thing quick, close to me. This is like how I am on TikTok. So right before I got on with Attorney Bederow, I got a DM in my Twitter from, wait for it, guys, Attorney David Yannetti. So you can't tell me shit today. That's all I'm going to say. And I'm on cloud 9. So I wish you guys the best night. Thank you so much for joining me. I love your face. I'll see you soon. Have a good night, guys.